Dear friends, we welcome you to Rajasomashekara's YouTube channel, that is CR Legal Awareness Web, with respectful salutations. Today I am going to talk about the scope and historical background and significance of the preamble of the Indian Constitution. The Constitution of India begins with a preamble. The preamble contains the ideals, objectives, and basic principles of the Constitution. The salient features of the Constitution have evolved directly and indirectly from these objectives which flow from the preamble. The preamble is based on the historic objective resolutions which were drafted and moved in the Constituent Assembly by Mr. Jawaharlal Nehru on 13th December 1946. The objective resolutions 1946 laid down the basic principles and ideas on which the Indian Constitution has to be made by the Assembly. The objective resolutions enshrined the aspirations and values of the constitutional makers. Under this, the people of India were guaranteed social, economic, and political justice, fundamental freedom, equality, and fraternity. The objective resolutions were unanimously accepted on 22nd January 1947 by the Constituent Assembly. Again, on 17th October 1949, the Constituent Assembly thought to discuss about the preamble, and there were many discussions about what should be included in the preamble and what should not be. Therefore, the Constituent Assembly, after some changes, adopted these resolutions as the preamble of Indian Constitution, which is the world's biggest constitution. The preamble of Indian Constitution was taken from the American Constitution. The Constitution of India was adopted on 26th November 1949 and it was enacted on 26th January 1950. By their sheer wisdom, prudence, foresight and diligence, the makers of our Constitution prepared a futuristic and vibrant document that reflects our ideals and aspirations of all Indians. The Constitution is the supreme law and the country's democratic framework, and it continuously guides us in our endeavors, and the Constitution is the fountainhead of our democratic system of government and our guiding light. The preamble gives guidance and states the purpose for which the Constitution of India is framed. It does not give any authority, but it encapsulates the fundamental objectives of the Indian Constitution and gives structure on which the Indian Constitution stands. The preamble to the Constitution of India embodies and reflects the fundamental values, philosophy, and the objectives on which the Constitution is based. The preamble is a sort of introduction to the statute, and it helps in understanding the legislative intent and policy. It lays down the main objective which the legislation intends to achieve. The preamble of the Constitution contains ideals which the Constitution seeks to achieve. The Honorable Supreme Court of India held that the preamble of the Constitution is of extreme importance and the Constitution should be read and interpreted in the light of preamble. Dear friends, it would not make any sense to read the Constitution without first reading the preamble of the Constitution, since The preamble is soul of the Indian Constitution, and it is the most precious part of the Constitution. The preamble reads, "We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation." In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Dear friends, the first part of the preamble states that we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens. We, the people of India, signifies that the power rests in the hands of the people. The Constitution is given by the people to themselves. Consequently, the government should elected by the people, for the people, and of the people. The sovereign, the concept of sovereignty is taken from Article 5 of the Constitution of Ireland. India is a sovereign state, which means that India is a supreme power and no internal groups or the external authority could undermine the authority of Indian government. As a sovereign state, India is free from any kind or form of foreign interference in its democratic affairs. The state is free to legislate on any subject in conformity with constitutional limitations. The sovereignty lies in the people of India. Socialist. The term socialist was included in the 42nd Amendment of Indian Constitution in the year 1976. Socialist implies social and economic equality. Social equality in this context means the absence of discrimination on the grounds of caste, color, creed, sex, religion, language, or birthplace. The word economic justice used in the preamble imbibes the concept of socialism. The directive principles, importantly Article 39, subclause B and subclause C, are flag bearers of social and economic justice. The Honorable Supreme Court of India held that the basic purpose of socialism is to provide decent standard of life and social security to people. Secular. The word secular was also inserted through the 42nd Amendment of the Constitution in the year 1976. Secularism is not an ideology of political parties, but it is the foundation of our country, because there is no official religion of India, unlike the status of Buddhism in Sri Lanka and that of Islam in Pakistan and that of Christianity in England. Our Constitution does not give a special status to any religion. The Constitution provides to all individuals and communities freedom to profess, practice, and propagate any religion or not to follow any religion. The Constitution prohibits discrimination on the grounds of religion. Secularism in the Indian context means that all religions are equal and the state does not exclusively support one single religion. Democratic. The term democratic indicates that the source of power of the government vests in its people. The democratic government is of the people, for the people, and by the people. The elected representatives rule the country and they are responsible to the people. Honorable Supreme Court of India held that democracy is the basic structure of Indian Constitution and rests upon the principles of majority rule and individual rights. The democracy in India works on the principle of political equality. Furthermore, it essentially means all citizens are equal before the law and there is no discrimination on the basis of religion, caste, creed, race, sect, etc. Hence, every Indian enjoys equal political rights. Republic. Though India became a free nation on August 15, 1947, it declared itself sovereign, democratic republic state with the adoption of the Constitution on January 26, 1950. The Constitution gave the citizen of India the power to choose their own government and paved the way for democracy. The word republic implies that the head of the state in India shall be an elected person and shall hold office for a fixed term of 5 years. A republic also means two more things. Number one, vesting of political sovereignty in the people and not in a single individual like a king. The absence of any privileged class and hence all public offices being open to every citizen without any discrimination. Later part of the preamble of the Indian Constitution states about justice, liberty, equality, and fraternity. Justice. The concept of justice was inserted in the preamble to secure its citizens political, social, economic justice, which are secured through various provisions of fundamental rights and directive principles. Justice means to secure the people from all sorts of inequality. Our Constitution abolishes untouchability, prohibits exploitation of women, children, and other weaker sections of the society, and protects interests and rights of minorities and tribal people, and advocates affirmative actions to raise the standard of people oppressed over the years. Liberty. The preamble secures to all the citizens of India liberty of thought, expression, belief, faith, and worship as a fundamental right. However, as liberty does not mean license to do whatever one likes. It has been made subject to reasonable restrictions as specified under Article 19 of the Constitution. The Honorable Supreme Court of India observed in its verdict that the term liberty does not mean absolute freedom, but the freedom with some lawful and social control to protect the interest of other people. Equality. Our Indian Constitution assures equality of status and opportunity to every citizen without any discrimination on the grounds of religion, race, caste, sex, or place of birth. It helps in protecting all the people and maintaining economic, social, and political justice among the citizens. Equality is a constitutional democracy means equal justice under the law. No one is above or beyond the reach of the law, and no one is entitled to unfair penalties based on the law. Fraternity. Fraternity refers to a feeling of brotherhood and sisterhood and a sense of belonging with the country and among its people. The preamble declares that fraternity has to assure two things: the dignity of the individual and the integrity of the nation are declared to be constitutional role. Fraternity as an ideological concept finds its birth in the French Revolution. Therefore, to give meaning to the ideals of justice, liberty, and equality, the Constitution makes fraternity as one of the foremost objectives to be achieved in a country like ours, composed of many religions, languages, and cultures. It serves as a source of togetherness, promoting unity and diversity. Article 51, subclause A of the Constitution makes it a fundamental duty of every citizen to promote harmony and spirit of brotherhood among themselves by transcending religious, linguistic, regional, or sectional diversities. The Constitution also promotes a sense of fraternity through single citizenship. Dignity of the individual. Our Constitution acknowledges that all citizens, men and women, equally have the right to grow and progress. His Lordship, Honorable Justice Korean Joseph, former judge of the Supreme Court of India, said that Indian Constitution as a great document has the dignity of an individual at the care of its heart. It's only when we understand the spirit of our Constitution that asks all of us to imbibe equality in our hearts, we can achieve a just society that registers no crime against women, that does not discriminate against its people based on their color, creed, sex, place of birth, language, religion, etc. This was our solemn resolve when we gave to ourselves the Constitution, that we secure for us, our people, the justice, liberty, and equality. His Lordship said further that our constitutional consciousness about equality, constitutional morality that preaches us to respect individual dignity, rising above narrow considerations of caste, religion, place of birth, etc. Unity and integrity. The preamble declares that fraternity has to assure two things, that is, dignity of the individuals and integrity of the nation. The word integrity has been added to the preamble of the Indian Constitution by 42nd Constitutional Amendment in the year 1976. Our Constitution expects from all the citizens of India to uphold and protect the unity and the integrity of the country as a matter of duty. The Constitution lays emphasis on the ideal of fraternity, which would foster unity among the citizens. Article 1 of the Constitution describes India as a union of states to make it clear that states have no right to secede from the union. Both the union and the states derive their authority from the Constitution. In India, there is only an Indian citizenship, and every power, legislative, executive, or judiciary, whether it belongs to the union or to the states, is subordinate to and controlled by the Constitution. The Constitution as clearly specifies the legislative and administrative powers of each, with the Supreme Court having the power to guard the distribution of powers. Article 1 of the Constitution aims to overcome the hindrances in national integration such as regionalism, communalism, linguism, casteism, and secessionism, etc. Finally, it is crystal clear that our Constitution builds a superstructure of political, economic, and social democracy, and this superstructure rests on three principles or pillars: liberty, equality, and fraternity. Dr. B.R. Ambedkar, the chairman of Constitution Drafting Committee, had cautioned that these principles are not to be as separate and unrelated. Dr. B.R. Ambedkar said, "Without equality, liberty would produce the supremacy of the few over the many. Equality or liberty would kill individual initiative. Without fraternity, liberty and equality could not become natural course of things." Friends, now the question is, can the preamble be amended under Article 368 of the Indian Constitution? The question was raised for the first time before the Supreme Court of India in the historic case of Keshavananda Bharati versus Kerala. In that case, the Honorable Supreme Court of India held that since the preamble is part of the Constitution, it can be amended, but subject to the condition that the basic feature and structure in the preamble cannot be amended. That means the power to amend the Constitution under Article 368 of the Indian Constitution does not include the power to alter the basic structure of the Constitution so as to change its identity. Keshavananda Bharati case has created history. The doctrine of basic structure is nothing but a judicial innovation to ensure that the power of amendment is not misused by the Parliament. The amending power under Article 368 of the Constitution can be exercised to amend the preamble so as to meet the challenges of the time offered by a rapidly changing social, political, economic, national, and international conditions and stipulations kept wide, elastic, and expansible by the constitution makers. Hence, it was held that there was no limitation on the power of constitutional amendment found in Article 368. Constitution under 368 grants power to the Parliament to amend whenever there is a necessity. Dear friends, as of now, the preamble has been amended only once so far, in 1976, by the 42nd Constitutional Amendment. The 42nd Amendment changed the description of India from a sovereign democratic republic to a sovereign socialist secular democratic republic, and also changed the words unity of nation to unity and integrity of the nation. Another question that arises is whether or not is preamble a part of the Indian Constitution. In this regard, there are two landmarking judgments that raised queries concerning the matter in question. That should preamble be considered as a part of the Constitution or not. The two landmarking judgments that raised this query are Berubari Union Case 1960 and Keshavananda Bharati Case 1973. The matter of Berubari Union Case was a presidential reference under Article 143 subclause 1 of the Indian Constitution. It was based upon an Indo-Pak agreement, that is, an agreement between both India and Pakistan, circling the Berubari Union and its exchange of enclaves, which was brought before the Honorable Supreme Court of India by a bench of 8 judges that was led by Chief Justice of Supreme Court of India. In the said case, the Honorable Supreme Court of India stated that the preamble is the key to open the mind of the makers, but it cannot be considered as a part of the Constitution. Whereas, in the case of Keshavananda Bharati, the Honorable Supreme Court of India has held that the preamble is a part of the Constitution and also referred to it as a provision of it. Therefore, the preamble is amendable under Article 368 of Indian Constitution. Dear friends, finally, I could say that the goals and objectives enshrined in the Indian Constitution are sought to be further clarified, strengthened, and concretized through directive principles of the state policy. Hence, it is essential that the preamble should be read along with the directive principles of the state policy, which laid down goals for the government to achieve. One of the members of the Constituent Assembly, Pandit Thakur Das Bhargav, said, "The preamble is the most precious part of the Constitution. It is the soul of the Constitution. It is a key to the Constitution. It is a jewel set in the Constitution." It is crystal clear that the preamble as such is widely accepted as the quintessence or soul and spirit of a constitution, as it embodies the fundamentals and the basis of the constitution, as well as the vision and commitment of a newly liberated nation and its people after it was passing through the inevitable birth pangs of national independence from an oppressive and colonial regime. Ladies and gentlemen, I conclude my speech about the preamble of the Indian Constitution. Dear friends, I am trying to upload hundreds of videos to create legal awareness for the common man and to educate the masses about the laws which are connected to our day-to-day lives. So aspire to inspire before our creativity and enthusiasm expires. Let us all strive to fulfill our aspirations. If you like the video, please comment, press the like button and share this video, and don't forget to subscribe and click on the bell icon. And if you want any videos on any topics of the Indian Constitution, please tell us in the comments column. Thank you, ladies and gentlemen.